Hi, this is David Fish from here at Romano Law, and today I'm going to be talking to you about union grievances and what an employee can do if they believe that their rights have been violated. Okay, so first, what is a grievance? It really is just a fancy way of saying complaint or a problem in the workplace. And grievances can take a lot of different forms. They can be based on a violation of the law. They can be based on a violation of a rule and regulation, or specifically, they can be based on a violation of a collective bargaining agreement or CBA. And a collective bargaining agreement is a document that governs the relationship between the employees and the employer. A trade union will negotiate these terms for all of the employees with a particular company, and the company and the employees will be bound by these rules. So if a good thing right off the bat is to know your collective bargaining agreement as well as you can. I'm not suggesting that every employee is going to know all 100 or 150 pages of the collective bargaining agreement, but generally knowing your rights is a really important thing because it's your life and it's your job. So what do you do if you feel like the collective bargaining agreement or some other rule or regulation has been violated? Typically, the first step is to talk with your union representative or designated person that handles grievances and complaints. And it's really important that you do that promptly because most of these collective bargaining procedures, union procedures, have fairly short time frames by which you have to raise an issue. So I think raising the issue and also doing it in writing is a really important thing. You will be surprised or maybe not surprised at the number of people that forget things, don't recall that an employee brought an issue to them. So doing these things in writing is really important. What will likely happen after you do that? That union representative will meet with a designated person from the employer, and they will first talk about whether this is the type of issue that actually can be grieved, if it's covered by the collective bargaining agreement. And if so, they'll likely try to reach a resolution fairly early on. And I will tell you, just to step back, the decision as to whether this is a properly grievable issue is probably first going to be done internally by your union, and then once they come to a decision, they will likely bring it to the employer for discussion. If it can be resolved early on, that's always the best result, but as you might imagine, that's not always what happens. So there will be a procedure for then escalating that matter, whether it be through a mediation process or an arbitration process, and your union representative and their counsel should help you with that. There also are certain claims that are not grievable under the collective bargaining agreement. There are disputes that fall outside of the coverage of the CBA. And those are things that you might be able to bring on your own or through an attorney outside of the union. And I know a lot of this stuff that I'm talking about right now might be new to a lot of you or seem kind of complicated. At times it can be, and that's when it's a good idea to consult an attorney that's experienced in employee representation and representing union employees.